Okay, let's finish up our discussion of this material with our talk on warranties. Warranties are promises. It's promises usually that the seller makes to the buyer when we're talking about contracts for the sale of goods. And the UCC has some things to say about warranties. So let's talk about what types of warranties are there and what coverage they provide. First, express warranties. Express warranties are ones that the seller makes expressly to the buyer. Any kind of affirmation of fact, either oral or written, that the seller might make about the quality of the goods being sold or any of the attributes of the goods being sold. These are promises. And the breach of a warranty could create the breach of a contract. These are promises that go along with the contract. So any kind of affirmation of fact that the seller makes about the product could create an express warranty. Like, for instance, a brochure sometimes that goes along with a product. Like if you buy a brand new piece of furniture, like a headboard for a bed, for instance, and there's a brochure that describes the headboard as being manufactured with 100% cherry wood. Well, that becomes an express warranty then. The seller is promising that, because it's a statement of fact, that the headboard is 100% cherry. There's no other kind of wood there. One other thing I want to note about this one is that it must be an affirmation of fact. Remember, we do let sellers engage in a little bit of what we call puffery, right, which is like the seller's talk exaggeration. So any kind of statement from a seller like, we use only the best ingredients. Well, that's really more of a statement of exaggeration or puffery. And even if they don't, in fact, use all of the best ingredients, then that's probably not the violation of a warranty. Next, any description of the goods can create a warranty. So in the contract, either oral or written into the contract, if the goods are described in a certain way, like being 100% purebred dog, for instance, well, then that can create an express promise or warranty. Or any sample or model. A lot of times, a retail seller, for instance, will have a sample or a model of a certain good on display. Well, by putting that out, what the seller is saying is that what I'm selling you, I'm maybe not selling you this one, the model, but the one I am selling you is just as good as the model that is being displayed here. The seller's conduct must have been part of the basis of the bargain also to be considered an express warranty. What does that mean? Some jurisdictions go a little further than others with this, but there must be some sort of reliance by the buyer on the promise. In other words, it's got to be part of the bargain. It has to be something that the buyer relied on, this statement or promise that was included in the contract that sort of induced the buyer to buy the goods in the first place. If it's a statement that's made and the buyer isn't even aware of the statement, maybe it's in a brochure that the buyer never read, and then later on the buyer discovers the statement and wants to sue for breach of an express warranty, then the buyer may have trouble with this element because they didn't actually rely. In fact, they didn't even know about it until after they'd already engaged in the contract. So let's go on and take a look at the other kind of warranties, implied warranties. These are not created by the seller's actions or words. These are created basically by the code itself, by the UCC. Implied warranty of merchantability is the first one we're going to talk about. Unless excluded or modified, a warranty that the goods shall be merchantable, which means they're average, at least of average quality, they're workable, is implied in the contract for their sale if the seller is a merchant of goods of that kind. So if we have a seller that normally sells hammers, let's say it's a hardware store, even if the seller makes no warranties or promises about the hammer, the buyer can be assured that the seller is impliedly making the promise that the hammer is of average quality, that it's fit for normal purposes. Any normal purpose for which you would use a hammer, this hammer is good for doing that. What is not included, for instance, if the buyer is using the hammer to be used for unreasonable or non-normal purposes, like they want to use the hammer as an anchor for a boat, or they want to use it as a grappling hook or something like that, the seller is making no promises or warranties that it's good for that purpose. but it is fit for normal purposes. Another implied warranty is the implied warranty of fitness for a particular purpose. Okay, this is when the seller, at the time of contracting, knows about a particular purpose of the buyer, and then makes an indication that the goods will be good for that purpose, for the particular purpose. So one example of this is a case that I read a while ago where a company they made these delicate Christmas ornaments, and they were very fragile, and the seller went to a shipping company and bought a bunch of boxes, and the boxes were of a certain type and made of a certain quality, and the seller of the boxes warranted that these particular boxes would be okay for shipping the ornaments. In other words, the seller knew the purpose that the buyer was using for the boxes, and then by selling them, impliedly warranted or promised that they would be good for that purpose. So, of course, what happened was the Christmas ornament maker loaded up these boxes with the Christmas ornaments, and the weight of the boxes actually crushed and destroyed them all. And the Christmas ornament maker then sued based on the breach of an implied warranty, because the seller knew what the purpose was that they were selling these boxes. Last two warranties here that I want to talk about under the UCC. These are implied also. The seller of goods warrants that he or she has good title to the goods being sold, and they're free of any kind of security interest that the buyer knows nothing about. And it says, unless the seller clearly excludes or modifies the warranty. By the way, if a seller explicitly excludes the warranty of title, then you might want to ask some more questions, because what they're saying is, I'm not saying I own these goods, but I'm selling them to you. Right? Remember our discussion earlier about bad guys and void title and voidable title and those kinds of things? Well, I didn't specifically mention then, but I will now because this warranty deals with it. If the bad guy steals goods and then sells them, so in my example, if you remember, it was March who stole a painting and then sold it to me. When he sells the painting to me, he warrants that he has good title to it. So if it turns out that he didn't, right, he only stole it and never had any title to it. If I can find March and track him down and sue him, I could sue him for the breach of this warranty of title. Because if you remember in that example, he gave me a void title, which means it was inferior to that of the true owner. In that example, it was President Thomas. And Thomas would get the painting back, and I'd be stuck with nothing. Well, then I could sue March, obviously, for a lot of things, fraud and for breach of this warranty of title, because what he gave me was no title at all. And then at the bottom here, unless otherwise agreed, a merchant warrants that the goods are free of any rightful claim of copyright, patent, or trademark infringement. In other words, that the goods that they're selling you aren't knockoffs, right? They're not fakes, or like when you go to, if you've ever been on the streets of New York City and someone offers to sell you one of his many Rolex watches, you might want to check that very carefully to find out that it is legitimately a Rolex or a Gucci bag or whatever it is, and that it's not basically a forgery or fake, and that when that person on the street sells you the Rolex watch, claiming that it's a Rolex watch, they are also making you the implied promise or warranty that they are not violating any trademark or copyright infringements. In other words, that it is legitimate. And so if it's not, then you could sue them if you can find them. Okay, let's talk about disclaimers. How do sellers disclaim certain warranties or provide defenses to certain warranties when it's claimed that they've breached them? First, disclaimer. Sellers like to disclaim warranties when they can. A disclaimer is a statement that a particular warranty does not apply. So when the seller is selling the goods to the buyer, they will make a disclaimer to say, these goods, the seller makes no warranty as to the quantity or attributes of these goods, those kinds of things. We're disclaiming all of those. Well, how do you disclaim, or can you disclaim, an oral express warranty? That may be disclaimed. So if the seller makes an oral express warranty, this headboard is made with only 100% cherry wood. okay, but that's made orally. Then in the contract, in the writing, if the contract is reduced to writing, then in the contract, if all warranties, oral warranties, for instance, expressed or implied, are disclaimed, and then the buyer signs it, then that oral express warranty is probably disclaimed as well. You probably can't enforce that. And remember also, the parole evidence rule would apply here too. So if those oral promises that are made at the time of negotiation, if they don't make it into the written contract, and the written contract is an integrated contract, then later on we can't use parole evidence to prove that those promises were made, and we're stuck with the four corners of the document. So this disclaimer kind of goes along with that concept. Also, what if we want to disclaim a written warranty, like in a brochure or in the contract itself? No, we can't do that. Written express warranties may not be disclaimed. And this makes sense because then the writing would contradict itself. Because if one place in the writing you made an express warranty, and then later on in the writing you said express warranties don't apply, which is it, right? This would create an ambiguity. So you can't do that. You can't disclaim an express written warranty. What about implied warranties, for instance, of merchantability? Can you disclaim that? Remember, that's the one that it's implied in every contract that the seller is making, saying these goods are fit for normal purposes. Can you disclaim that? And the answer is yes. You can disclaim, but you have to use the word merchantability in your disclaimer, right? It's very specific as to that. And it must be conspicuous. You can't hide it at the bottom of your document and that kind of thing, and expect to have that enforced. Also, note, a lot of states prohibit a seller from disclaiming an implied warranty if you have a sale of consumer goods. So if you have a consumer on one end of the transaction, then a lot of times you can't disclaim these kinds of implied warranties. Okay, the general rule for disclaimers, and you've probably seen this language before in contracts, but you may disclaim the implied warranties, unless again it's those specific ones for consumer goods, by using terms such as is, or without, or with all faults, rather. A lot of times you'll see as is. That means it's a general disclaimer of the implied warranties. What about remedy limitations? Can the seller limit, in the terms of the contract for instance, what remedies might be available as a defense, in essence, if one of these warranties is breached? Well, yeah, the code does allow that. A limitation of remedy clause, it's usually got to be in the contract and written, by which the parties may limit or exclude the normal remedies is permitted. So you may have a contract provision that says, in the event of a breach of the contract, the buyer agrees to limit the remedies sought to only a refund, or only to repair of the good that is defective, or something like that, or replacement. So we can limit those. What about consequential damages? Can we exclude consequential damages in our contract? Well, we can do that. An exclusion of consequential damages is allowed unless it's unconscionable. Remember what unconscionable is? Unconscionable is where the contract term is so one-sided as to be unfair, and it's so unfair that it shocks the conscience of the reasonable person. So they are allowed, and again, you may run into some problems trying to exclude consequential damages like lost profits and those kinds of things that a buyer may try to claim if the buyer is a consumer. Courts look at those contracts a lot more closely in terms of whether they're unconscionable, and so you may run into problems trying to exclude consequential damages. But on other contracts and with other warranties, you can generally exclude that. Okay, let's talk about privity. I know you know about privity. We talked about it with third-party rights. Remember that? Privity is where the general rule that says only the parties to the contract can enforce its terms, including any warranties. So what do we do with the rule of privity? Well, when two parties contract, they're in privity of contract. In the past, injured parties could only sue the party with whom they had privity. Now we've opened that rule up a little bit and we've changed it. And you can see where the changes lie. In cases of personal injury, right? So this is where maybe we sell a good and the good is defective that causes the buyer an injury, a physical injury. In that case, the injured party may sue any responsible party, regardless of privity. Okay, so this allows, if I go our normal chain of sale, if I'm a customer and I go to a retail seller, one of the big box stores, for instance, and I buy a product, and I take it home and it's defective, and the defect actually causes me a physical injury. It catches on fire or it explodes or something, causes me a physical injury. I have, as a consumer, I have privity of contract with the retail seller, the place where I bought it. But maybe they're out of business, or I don't want to just limit my lawsuit to the retail seller. What if I want to sue the manufacturer of it? Right? So let's talk about, maybe it's a cell phone, and let's use, oh, I don't know, maybe Samsung as an example. And I buy a cell phone and I plug it in to charge it, and it catches on fire, and it causes me a physical injury. Now, I bought the cell phone at Best Buy. So I actually have privity of contract with the retail seller, Best Buy. I don't have privity with Samsung. But because of the changes in the rules, I don't have to. If I suffer a personal injury as a result of a defective product, I can sue Samsung directly, and I don't need privity. But if it's a case of purely economic loss, if I didn't suffer a personal injury, I just lost money as a result of the defective product, for instance, then the injured party may be required to have privity with the defendant. Now, some states have changed this to where a consumer can still sue, for instance, the manufacturer, even if it's just an economic loss, but not every state has that rule. Some other factors that limit the seller's responsibility. Defenses, we call them, right? Another defense that might come up to enforcement of a warranty might be the buyer's misconduct. The buyer buys the product and then misuses it or uses it for other than its intended purpose. Misuse of the product by the buyer will generally preclude a warranty claim. Right? So if I sell a certain product to the buyer and the buyer uses it for some strange, I sell them a hammer and they use it as an anchor for a boat, well then the misuse of that product is going to give me a defense to any kind of implied warranty, for instance, claim that the buyer may have. Also, statute of limitations. And notice, remember, statute of limitations gives the buyer, in our context here where they're trying to enforce a warranty, gives the buyer a limited time to file a lawsuit. And if they wait too long, they're forever barred from doing that. So the code, UCC, prescribes a 4-year statute of limitations for breach of warranties. Now, I will say that the proposed revisions to the code proposed to extend this by a year, so it would be 5 years. But regardless, we have a period of time there. And if the buyer waits too long, then they can never enforce the warranties because the courts will, in essence, dismiss the lawsuit. Also, the UCC does have some language that requires a buyer to notify the seller of any defects within a reasonable amount of time. So even though you have 4 years to file the lawsuit, for instance, as a buyer for breach of warranty, if you know about the defect way before the 4-year statute of limitations time is over, and then you wait 3.5 years and file your lawsuit without notifying the seller at any point before there, then the UCC says the buyer may also be limited. This may be a defense to the seller because the UCC does require that the buyer notify the seller within a reasonable time of discovering the defect. In other words, you can't just wait around for a long time and then spring it on the seller later on. And the purpose for this really is for the seller to have a chance to cure the defect, to fix the problem, really to avoid any kind of lawsuit at all. So there is language to